Hello, and welcome back to the Voloshen Law Firm. Thank you again for tuning in and for making us your choice for all of your naturalization and immigration needs over the last year. We are delighted to work with you, and we thank you for your confidence and for your commitment to helping us help you build the American dream. Today, I would like to talk to you about some of the recent updates and news in the immigration field. Over the last 8 months, we have seen literally a plethora of changes and updates in the immigration field. One of the most significant and one of the most published news have been news about changes at the southern border of the United States across Mexico. Because of turmoil in the world, including my home country of Ukraine, we have seen a flood of new immigrants cross the US-Mexican border into the United States in order to seek shelter, in order to obtain safety, and in order to temporarily relocate and help their families be safe from the ravages of war. As a result, some of the changes at the Mexican border are significant and deserve to be discussed in this video. First, it is important to note that when somebody crosses the border, there are several designations they may be assigned. One is called the arriving alien. Second, paroled alien. And third, somebody who enters the United States on a visa or other forms of inspection. When somebody comes to the United States on parole or arrives and is designated as the arriving alien, there are certain benefits that he or she can enjoy which are not available for those people who cross the border and present themselves to the United States Customs and Border Patrol. It is important to note that those people who are designated as present aliens lose some of the benefits that others enjoy. One of those benefits is the ability to apply for immediate work authorization, or as we call EAD. Somebody who crosses the border and is designated as arriving alien and receives parole can automatically apply for work authorization under the C11 category, and therefore can help themselves and their families automatically qualify to work and obtain the Social Security number. Now, when I say automatically, it does not mean that somebody can start working the next day. However, they may apply for benefits and usually within 3 or 4 months are able to obtain the necessary documents to work in this country legally. If you have any questions about how you were designated after crossing the US border with Mexico, please call our office so we can examine your documents, your notice of action, and inform you about whether you qualify for that immediate benefit of work through parole. The news in this field are the following. A few days ago, we have learned that the United States Customs and Border Patrol are now utilizing the assistance of Mexican immigration officers to inspect people that are crossing the border at the San Isidro point of entry. If you are somebody who crossed the border through Mexico into the United States in a vehicle lane, you most likely remember that your inspection took place as soon as you crossed the border into U.S. territory, and you were inspected and most likely questioned by U.S. Customs and Border Patrol officers about whether you qualify for that humanitarian parole. As a result of the overwhelming flood of people at Aramesa and other ports of entries like San Isidro, now the United States Customs and Border Patrol will utilize assistance of migration officers from Mexico in order to deter people from entering the United States and possibly returning them. This is a concerning news for a lot of our clients because Customs and Border Patrol officers at the US border were well known for fundamentally and thoroughly looking into the qualifications of humanitarian parole. Migration officers in Mexico are, however, officers that are not as well known to U.S. immigration lawyers, and therefore there are a lot of rumors about schemes and both legal and illegal bribes, as well as other different programs which do not allow people to come to the United States. We are quite concerned as an immigration lawyer community about different methods by which people will be stopped or deterred from entering the United States and seeking parole and humanitarian benefits as a result of fraudulent or maybe bribing actions on behalf of the migration officers in Mexico. Before making a journey to the United States, I caution people to really learn about all of the different scenarios that could take place as they make their way from Mexico to the United States. Most recently, we've also heard about a class action lawsuit which has now been approved on behalf of migrants who were returned to Mexico as a result of what is called Act 42. I want to remind you that at the outset of the pandemic in 2020, the Trump administration implemented a program called Act 42, which allowed for people to return to Mexico and not allowed to enter the United States, even after presenting themselves with eligible asylum claims, solely based on a directive issued by the Customs and Border Patrol initiatives, as well as the Center for Disease Control, due to the pandemic. In other words, on the account of public health, people were turned back into Mexico and not allowed to enter, and the Trump administration used this policy largely in order to deter people from seeking entry to the US through the Mexican border. When the Biden administration came into office in early 2021, the program was kept in place in order to obviously deter people from flooding this Mexican-US border, and obviously helping to withstand the large inflow of migrants from the South. That program, however, came under scrutiny, and many people, including my immigration lawyers, sued on behalf of the victims of this program and asked for first a temporary stay and then a permanent ban to the program. I'm happy to report that only a few days ago, the federal district court that reviewed this case, I believe in Texas, has now put a temporary stay to the implementation of the ban for 5 weeks. And starting in January of 2023, Act 42 will all together be gone, and people will no longer face the deterrence of seeking credible asylum claims across the border, and will be allowed to enter the United States as if Act 42 did not exist.